Thank you very much, Mr. President, for this opportunity to contribute to this motion. By way of short background, Mr. President, the Data Protection Act, Chapter 2204, which is an act to provide for the protection of personal privacy and information, was assented to on the 22nd of June 2011, and there have been partial proclamations since January 6, 2012, and August 23, 2021. Data protection in Trinidad and Tobago is governed with respect to not only the Data Protection Act, which I will refer to shortly as the DPA, but also the Freedom of Information Act, 1999. The DPA provides for the protection of personal information by public and private bodies, establishes a Data Protection Authority Office, the Office of the Information Commissioner, and covers enforcement of the Act and penalties for breaches. The Freedom of Information Act promotes good governance through transparency and accountability in government decision-making. Mr. President, data protection is the process of safeguarding important information from corruption, compromise, or loss. Data protection law has developed in Trinidad and Tobago over the last decade in the DPA, the object of which act is to ensure that protection is afforded to an individual's right to privacy and the right to maintain sensitive personal information as both private and personal. Data is integrated into almost all aspects of our lives, and it stimulates economic activity. It changes the way we do business. It affects the interpersonal relationship between persons in the private sector and will affect the way we as a government deliver services to the citizens of Trinidad and Tobago. In his contribution to this debate, Mr. President, my learned friend, Independent Senator, the Honourable Anthony Vera, and let me digress for a moment just to spend a little time on the term my learned friend. It is a term that we have used in the other place to which my learned friend and I belong before we came to this chamber. And it has to do with the respect that we have for each other's abilities and notwithstanding differences and sometimes strong differences that we may have from time to time. And I regret to say that since my entry to this august chamber, other persons to whom I have previously referred to as my learned friend seem to have forgotten the code of honor that informs being a learned friend. My learned friend, Independent Senator Anthony Vera, has given us a scholarly contribution which the government has carefully listened to. To his credit, Senator Vera has acknowledged that he would not like to believe that because this act was piloted under a different administration, that there is no imperative for this government to move things forward. And he is correct. And for all that I say here today, Mr. President, I wish to underscore to our citizens that this government of the People's National Movement was the prime mover on the national policy on data protection in December 2005. The policy document, Mr. President, produced by the then Minister of Public Administration and Information, at the time under the government of the late Right Honourable Prime Minister Patrick Manning. With your leave, I will read a few highlights from that document, the National Policy on Data Protection, December 2005. And only to highlight the importance which this government and the previous government under the Honourable Patrick Manning has placed on the importance of data protection. It highlights the fact that it covers a lot of areas, and with your leave I read, and any policy of legislation that purports to deal with all these matters will need to be accompanied by a significant number of guidance documents and regulations clarifying the specific requirements of the general policies. That is paragraph 2.1 of the National Policy on Data Protection, December 2005. At paragraph 2.2, why is a data protection policy necessary? It told us then that privacy has long been understood to have a value in a civil society that respects the inherent rights and values of mankind. The Constitution of Trinidad and Tobago recognizes that right, the right of privacy to an individual and within a family. It highlights for us at paragraph 2.3 the government protection of personal privacy, speaking to the importance even then of the Freedom of Information Act. And at 2.4, it makes the point, importantly, of linkages with other laws, which is something that I will touch on in my contribution here today. That is to say, the Data Protection Act, envisaged as it was as far back as 2005, is not a stand-alone piece of legislation. So that in 2005, we are reminded by the December 2005 national policy of the then People's National Government that it would have to coordinate with laws of contracting and the Commercial Code, with the Evidence Act and admissibility and validity of electronic transactions, with Computer Misuse Act, with intellectual property legislation, with consumer protection, with laws on electronic transactions, with laws to protect company information. It is a long document, but I will not trouble this House with it in detail, but it is a very important historical document which we remind ourselves lays out what was then the Vision 2020 vision of the People's National Government, which continues today and going forward for the safety and security of private lives of the citizens of this country. The Data Protection Act, which was passed in this House, Mr. President, has a number of sections, some of which have now been proclaimed, others which await proclamation, as we seek to coordinate the holistic development of that particular piece of legislation with other laws still to be brought into effect. And I will refer in a little detail to two sections in particular. First of all, Section 4, and I remind this House most remarkably that when he piloted his motion, the Honourable Senator Wade Mark said this: the government of Trinidad and Tobago did not proclaim Section 4 of the Act, so you and me and the citizens of Trinidad have no protection, Mr. President. Well, I would have thought that the Honourable Senator piloting what he claims is an important motion would have sought to get it correct, because every speaker who has preceded me and followed Senator Mark has taken the time and trouble, which I will not linger on, to remind him that Section 4 has been proclaimed. Another important section of the Data Protection Act which has been proclaimed, Mr. President, is Section 6 of that Act. And again, with your leave, I will touch on just some of those principles. Section 6 of the Act provides the following principles are the general privacy principles which are applicable to all persons who handle, store, or process personal information belonging to another individual, another person. And it proceeds from subparagraph A through to subparagraph L. A, an organization shall be responsible for the personal information under its control. One can just pick the number of instances of areas within the personal general privacy principles which are part of the existing law that obtains in this country now. And I won't dwell on it in detail. I am sure that all members present are aware of those general privacy principles which are part of our law, but there is an important one that I want to touch on. L. So if I were to reread the introductory, the following principles are the general privacy principles which are applicable to all persons who handle, store or process personal information belonging to another person. L, personal information which is requested to be disclosed outside of Trinidad and Tobago shall be regulated, and comparable safeguards to those under this Act shall exist in the jurisdiction receiving the personal information. What does that section mean? It means that in the full proclamation of this Act, we have to ensure that our legislation is consistent with best international practices. We have to ensure that our personal protection of individuals' personal information under this legislation has cross-jurisdictional compatibility and consistency. And that is important, and I will return to that. Mr. President, Senator Mark has made quite a lot in his contribution of sections 42A and 42B of the Act. Section 42 creates exceptions to the requirement for consent for disclosure of personal information. Section 42A and B provide, and I quote from the legislation, except as provided under any other written law, personal information under the control of a public body may only be disclosed, A, for the purposes for which the information was collected or compiled by the public body, or for a use consistent with that person. And Section 42B, for any purpose in accordance with any written law or any order made pursuant to such written law that authorizes such disclosure. The point I emphasize here, Mr. President, is that these two sections cannot be read as silos on their own. They are to be read in conjunction with all of the general privacy principles to which I have earlier referred that are part of the law under Section 6 of the Act which has been proclaimed. And some time was spent on that, and I will not repeat this equally scholarly contribution of Senator the Honourable Hassel Backus, Minister of Digital Transformation. While disclosure of personal information can occur for a specific purpose, the privacy principles will apply to all persons who handle, store, or process personal information belonging to another person. It is, Mr. President, with respect, a work in progress. An ongoing review and consultation on amending the Data Protection Act has been ongoing under this administration since 2016. In 2016, the then Minister of Public Administration and Communications, as the line minister with responsibility for the operationalization and administration of the Act, indicated that the Act needed to be reviewed holistically so as to harmonize the competing public interests of protection of personal privacy on the one hand and freedom of expression, including freedom of the press, on the other. The ministry then embarked on a policy review of the Act with a view to exploring the creation of exemptions from the enforcement of provisions of the Act for certain categories of expression, inclusive of investigative journalism. The proposed policy proposed then that such exemptions can be availed upon as part of an appropriate balancing of the public interest of privacy protection against journalistic publication of material. The point there being that whilst the Data Protection Act will protect public information, journalism, and that is the fourth estate, has the right to go out there and get information so as to keep the public informed, and one has to be careful in the application of the Data Protection Act to allow journalistic freedom in order that the fourth estate can continue to do their job. The ministry has noted the role of that fourth estate in ensuring the public's involvement in appropriate checks and balances on governmental action as an important pillar of our democracy. Further to the ongoing policy review of the Act, Mr. President, the government has continued to engage in stakeholder consultation. In 2018, the government undertook a comprehensive review of the Act again. The findings of the review confirm that the Act was not consistent with best practice in data protection as defined by the European Union's General Data Protection Regulation, the GDPR. For instance, the Act has no specific or expressed provisions in the areas of electronic marketing, online privacy, including cookies and location data, and breach of notification. It was also noted that the Act was deficient in many other areas as part of an ongoing consultation that the Minister of Digitalization is engaged in with our international partners. Further, in November 2019, the then Minister of Communications held a consultation with stakeholders to obtain feedback to amend the Act. Issues raised included, among others, the following: the Office of the Information Commissioner in terms of providing appropriate power, structure, and composition, the protection of children and adolescents, age of consent in a world in which everybody is online and we have to protect our young children. Consideration for defined categories of expression, including journalistic, literary, and artistic expression. Trinidad and Tobago is one of the most artistically creative countries in the world, and we have to be very careful to ensure that in the playing out of and the full proclamation of the legislation, we give recognition to the rights of our artistic community to be able to be out there practicing and occupying the space in the artistic world that they are free to operate in, and not to be hamstrung and circumscribed by oppressive legislation. All of these are things that are actively under consideration as we look to proclaim the Act in its full ambit. The need for uniformity in the definitions used in the legislation. The ongoing exercise has ascertained that there are discrepancies between definitions provided in the Data Protection Act and in other pieces of legislation that already exist in the corpus of law in Trinidad and Tobago. That is a painstaking, careful exercise that needs to be undertaken in order to ensure that on the full proclamation of this legislation, it is consistent with, and therefore it will require amendments to other pieces of legislation in addition to simply proclaiming the Data Protection Act in its full ambit. It was recommended, Mr. President, that the government of Trinidad and Tobago adopt the principles guiding the GDPR and incorporate them into a new data protection law to be adopted. To address those deficiencies, the government is desirous of updating and harmonizing the Act in line with international standards. The government understands that the pace in which the reform of digital transformation has transcended globally is such that we have to keep pace. The Prime Minister in July 2021 established the Ministry of Digital Transformation for, among other reasons, to lead on an in-depth review of the data protection legislation. And this House has had the benefit of the contribution of the Minister of Digital Transformation in that regard. As part of the comprehensive approach that is being undertaken, the Ministry of Digital Transformation is in the process, Mr. President, of, among other things, the full operationalization of the Electronic Transactions Act, and has continued to pursue implementation of the Electronic Identity, the EID program. In this regard, it is envisaged that the EID program will be subject to the legislative framework applicable to electronic signatures and electronic authentication, notably the Electronic Transactions Act. The full operationalization of the Data Protection Act will involve implementation work with other ministries, the interoperability framework for ministries, departments, and agencies to enable a robust interconnectivity of systems and exchange of data between the MDAs. In this regard, data protection, data privacy and protection issues, and the regulation of same to ensure compliance with general privacy principles are a work in progress of particular concern. There is the Telecommunications Act and its regulations. The Ministry of Digital Transformation and the Telecommunications Authority have been in communication regarding the approvals process for the implementation of the policy informing proposed amendments to this Act as well as to the Telecommunications Act, along with a specific proposed amendment package. The Act in its current form, Mr. President, does not comply with corresponding data protection laws worldwide. That is why I singled out Section 6L of the General Privacy Principles. The Act in its current form does not comply with corresponding data protection laws worldwide, which are evolving at a critical stage even as we sit here today. For example, there is no single data protection legislation in the United States of America. Rather, this is governed by the federal and state level laws. The EU, on the other hand, has a significant breadth of data protection laws which impact on cybercrime activity, and the EU's position is to enforce standards for base erosion and profit sharing, BEPS, and the automatic exchange of taxpayer information. With the current Act, while the current Act presents restrictions for the protection of personal information in this jurisdiction, other countries are far more developed in the strides that they are making to protect personal information, including information which is to be and is being transferred across borders. Section 6L of the current Data Protection Act. The recent UK appellate case of Soriano and Forensic News LLC and others, reported in 2021, EWC Civil Appeals at page 1952, is a good example of the strides being made in cross jurisdictions. That case, I won't trouble this House unduly, involved a libel case by a naturalized British citizens. And part of the problem involved in that is that his data had been stolen, and it was a case that has made a significant input in recognizing that the jurisdiction for data protection operates across borders, inclusive of monitoring how organizations who collect data behave or treat with that information. So it is not just a question of how organizations and persons within Trinidad and Tobago manage their data protection under this Act, but how our management of our data under this Act corresponds with, coheres to, and is consistent with international cross-border jurisdictional protection of data. It is, Mr. President, a work in progress. It is a work in progress, and it would be a misrepresentation of the fact to suggest that since 2016 we have stood still and no work has been done in a decade on progressing our data protection laws. It is a continuing work in progress, and I dare say, which is not something that those in the opposition exercised when they were in government, that a responsible government will work incrementally along the way to ensure that when they pass laws that impact the daily lives of citizens, they do it in a balanced way that takes into consideration all relevant considerations. A work in progress incrementally along the way. Holistic being the operative word, Mr. President. We must fully proclaim the Act. But I urge this honorable chamber, we must not rush to proclaim the Act unless and until the necessary jurisdictional analysis and proper analysis of international best practice has been conducted. The government, particularly through the Ministry of Digital Transformation, is working with the Ministry of the Attorney General and Legal Affairs and has under active review our Data Protection Act, our privacy protection rules, and the general principles that prevail in other jurisdictions. It is this government's intention to bring the necessary amendments to the Act to the Parliament in the shortest possible time frame so as to ensure that the Act as amended fulfills its intended purpose, to protect privacy and personal information in a responsible fashion and in a manner that does not unduly infringe upon civil liberties. In its current form, the Act does not currently reflect international ideals or views of the protection of personal data and contains several ambiguities, misconceptions, and omissions. Accordingly, we are of the respectful view that the Act ought to be amended before being fully proclaimed. Our independent senators, and thank God for them, have made balanced and valuable service to this motion, eschewing populist soundbites. I have already spoken of and paid tribute to the remarks of Senator the Honourable Anthony Vera. In the course of Mr. Honourable Minister Hasselbach's contribution, Senator the Honourable Dylan Remy asked a very pertinent question of Minister Bacchus. What kind of time frame are you looking at in moving forward for the amendments to come to this House? An intelligent, on-point, relevant question. Senator the Honourable Dr. Varma Diyal Singh has also spoken in balanced and relevant terms. He has pointed to the fact that the Act must be fully proclaimed. We accept that. No one takes issue with that. He has been comprehensive in his review of what has been proclaimed and what has not. He has pointed to the fact that the legislation has received the scrutiny of the Joint Select Committee and has even suggested that perhaps we should return there one last time to review such revisions as need to be done. And very pointedly, and I quote from Hansard, he suggested we must quickly, not immediately, come up with a timeline commitment. We accept that, Mr. President. There is work to be done in order for the government to complete its consultations and review the existing legislation to prepare the necessary amendments to bring Trinidad and Tobago up to date with international best practice. Mr. President, the motion before this House in the terms proposed by Senator Wade Mark in its resolution paragraph asks for a resolution that the Senate call on the government to immediately proclaim, the word immediately is used, to proclaim the remaining sections of the Data Protection Act and in the process ensure the necessary checks and balances aimed at safeguarding citizens' fundamental right to privacy. I have asked for an amendment to be circulated, Mr. President, on behalf of the government, and I have circulated that by proposing that the word immediately be replaced with the words as soon as possible. If my proposed amendment is accepted, the resolution before this House will accordingly read, be it resolved that the Senate call on the government to, as soon as possible, proclaim the remaining sections of the Data Protection Act and in the process ensure the necessary checks and balances aimed at safeguarding citizens' fundamental rights. In the circumstances, Mr. President, I accordingly beg to move that in accordance with Standing Order 43, the motion be amended by deleting the word immediately in the first line of the resolution and substituting the words as soon as possible. Mr. President, I beg to move. Thank you very much.